Good morning, good afternoon, or good evening. This is Pamela, and you are watching Pam Entertainment TV, where we review movies, television series, and incidents in pop culture to see how those incidents may or may not affect our daily lives. Listen, yesterday we found out that Blake Lively had been sued. We found that out via TMZ. We found that out about different outlets. I'm going to just share quickly. Here is the Hollywood Reporter. It says Blake Lively sued for defamation by crisis PR firm, and it was a fuse. A man named Jed Wallace targets the actress, naming him in the sexual harassment and retaliation complaint she filed with the California Civil Rights Department. Now, if we don't understand that Blake Lively mentioned this man in several of in the initial report to the New York Times, she mentioned his name in the CRD complaint. And then you remember I had a stream where we read that she was going to depose someone in Texas and then withdrew that one. So this is who we are speaking of. I have a copy of the complaint. It is 10 pages. And so let's do it. Let's go over this complaint, these 10 pages. This was filed in the United States, this report, Western District of Texas, Austin Division. It's by Jed Wallace of Street Relations Incorporated, and he's suing Blake Lively in a civil action. He doesn't complaint for declaratory judgment and defamation. Says to the Honorable Court, one, Jed Wallace and Street Relations, Inc. bring this action for declaratory judgment and defamation against Blake Lively and would show as follows. The parties. Wallace is a citizen of Texas and resides within the Austin Division of the Western District. He owns a company, Street Relations, Inc., which is a crisis mitigation firm engaged by clients to help navigate real-life human crisis, threats, hold on, I lost my real-life human crisis, threats, trauma, and mental health concerns. It helps primarily families and individuals when they find themselves unjustly attacked, extorted, doxxed, swatted, scammed, or need help navigating through the most frightening situation. Street is a corporation organized under the laws of the state of California with its principal place of business in Texas, and therefore a citizen of a state other than New York. Lively is an actress and entrepreneur and is a citizen of New York. Factual background. On December 20th, 2024, Lively filed a complaint of employment discrimination before the state of California Civil Rights Department. The CRD named Lively as a complainant and Wallace and Street, among others, as respondents, and alleged that they engaged in a variety of conduct in violation of California Government Code Section 12940 and Title VII of the Civil Rights Act of 1964, Title VII. The CRD complaint went on to allege the plaintiff's conduct includes sexual harassment, retaliation, failure to investigate, prevent, and or remedy harassment, and aiding and abetting harassment and retaliation. Exhibit 1, which he has put through here, the CRD complaint attached here to, incorporated in. So we'll look at that because I don't think I looked at the CRD report. The CRD complaint also asked politely to please see attached complaint for specific details. The attached complaint, which we attached incorporated Exhibit 2, has been described as a precursor to a lawsuit, although it had all the indicia of a standalone legal complaint. Indeed, some media subsequently published the precursor under the headline, "Read the Complaint." The precursor named Wallace and Street as defendant and sought damages for one, this right here, I'm not going to say it, under California federal law, retaliation under California federal law, failure to investigate, prevent, and or remedy harassment under California law, retaliation under California labor code, aiding and abetting harassment, retaliation code under federal law, breach of contract, initial infliction of emotional distress, negligence, false light invasion of privacy under the California Constitution, and interference with prospective economic advantage. On the same day, the CRD complaint with the precursor attached filed December 20th, 2024, the Civil Rights Department issued Lively a right to sue letter. So that's when she put the suit, she sued the next day. Lively and her agents provided the precursor to various media entities for out of court republication, and because the allegations contained therein, it may headline around the world. According to Elle magazine, which linked the precursory document as did many other media, see Exhibit 4, attached here hereto and incorporated herein. The precursor was followed on or about December 31st, 2024 by a, quote, formal suit in the United States District of the Southern District of New York. Wallace and Street were widely reported to be defendants in the formal lawsuit, although they were not. The confusion having been sown by the precursor, as Lively admitted she knew of no facts to support the allegation against Wallace or Street. Indeed, having been the one harassed, she knew the exact opposite. Neither Wallace nor Street had anything to do with the alleged harassment, retaliation, and failure to investigate, or aiding and abetting the alleged harassment or alleged retaliation. Neither could they have breached a contract with Lively because no contract exists. And they were not involved in any of the events depicted in either the precursor, where they were named as defendants, or the formal lawsuit, where they were not named, which would give a rise to a duty toward defendant, negligent, or any other tortious conduct, false light, intentional infliction of emotional distress, or interference with prospective economic advantage. Then on January 21st, 2025, Lively filed her verified petition for Rule 202 disposition in Hayes County, Texas, against Wallace, but not Street, alleging on information and belief that Wallace was a subcontractor to a company called TAG to assist them in their unlawful retaliatory social combat campaign against Lively. So this is who she came after when we heard that she was deposing somebody in Texas. The 202 petition conceded that Lively has no facts supporting the allegations she made against Wallace and Street in the precursor, which made headlines around the world, as she now, apparently under the threat of sanctions from one of the plaintiff's attorney, sought to investigate the scope of Mr. Wallace's conduct. According to the Hayes County online court records, Lively non-suited her 202 petition today. So non-suited possibly means that she dismissed it, let it go. We'll check that out. The 202 petition was a transparent attempt to chill painters' free speech rights and would have been fodder for a motive to dismiss under the Texas Citizens Participation Act, Chapter 27, Texas Civil Practice and Remedy Code, the anti-SLAPP statute. We heard about anti-SLAPP statutes in California are very strict, and anti-SLAPP statutes in New York are kind of lenient, from what I understand. But you need to ask a lawyer for that, whose purpose is to encourage and safeguard the rights of persons to speak freely. The statement of fact, actual or implied, of and concerning plaintiffs in the precursor and CRD complaint are false, defamatory, made with either negligence or actual malice, and have caused millions of dollars in reputational harm, including both general and special damages through the emotional harm. Actual damages and real and projected loss of business, Wallace and Street, in an amount that exceeds $1 million. So again, he filed this in Texas. This court has jurisdiction under 28 U.S.C. 1332 because the matter exceeds the sum or value of $75,000, exclusive of interest and cost, and Wallace and Street as plaintiffs are not citizens of the same state as a sole defendant Lively. This court may exercise personal jurisdiction over Lively because she has availed herself of the forum by filing a Rule 202 petition in Texas on the subject of this matter. And so they ask you to see these particular cases to cite. They're citing these particular cases. Let's go down. In addition, her defamatory statements were aimed at Texas, where both plaintiff resides, and they undoubtedly cause harm in Texas. Venue is proper because, as Lively alleges in her Rule 202 petition, a substantial part of the underlying event that would have give rise to the claims being investigated occurred in Hays, Texas. Part of the Austin Division of the Western District of Texas. In addition, a defamation plaintiff is accorded great deference in his choice of form, especially when it's his home venue where the defamation is mostly keenly felt. That means the standard for the venue under the venue statute, C 28 USC. Oh, I'm so sorry, y'all. I didn't have my comments up. Hello, Chadigi. Y'all hit that like button for me. I really do appreciate it. Hit that like button. And if you're just joining us, we're going over the 10-page complaint by Jed Wallace, who Blake Lively had put in her initial complaint, was one of the defendants that had harassed her and defamed her. First cause of action, Declaratory Judgment Act. The Declaratory Judgment Act allows a court to conclusively adjudicate and declare the rights and other legal relations of any interested party seeking such a declaration. The purpose of the Declaratory Judgment Act is to afford one threatened with liability and an early adjudication without waiting until his adversary should see fit to begin an action after the damage has occurred. And then he cites and quotes all these little different cases. As explained above, Ms. Lively has alleged 10 different causes of action against Wallace and or Street, although she now admits that the CRD complaint and the precursor was caused great harm to plaintiffs' business by way of lost business, exceeding the threshold monetary limits necessary for diversity jurisdiction as it was reported around the world, was without factual support, even though she now belatedly attempts to attain some through her 202 petition. This claim is justiciable, and the court has authority to grant the relief plaintiff seeks, which is that 1, they did not breach any contract with the defendant for the reason that, among others, no such contract exists. 2, they did not engage in any acts of harassment or retaliation, failure to investigate, prevent, and or remedy harassment, or aid and abet the alleged harassment or retaliation for the reason, among others, that they were not given, present, or otherwise involved in the events giving rise to the alleged harassment, nor did they have contemporaneous knowledge of the alleged events of harassment or retaliation. 3, they did not have a duty to defendant, which would give rise to a claim for negligence. And 4, they did not engage in any torturous conduct toward the defendant. Plaintiff seeks a declaration pursuant to 28 USC Section 2201. Second cause of action, defamation. The precursor and the CRD complaint named Wallace and Street as defendants or respondents and falsely stated that they had engaged in 10 illegal acts under state and federal law. Neither the precursor nor the CRD complaint were privileged because, among other reasons, they were provided by the defendant or her agents to third parties, including media outlets. Defendant knew or should have reasonably anticipated, indeed she hoped, that these allegations would be republished around the world, and as a result, defendant is responsible for republication damages. The statement of fact and concerning plaintiffs in the precursor are false and defamatory. They are made either negligently or with actual malice. So if the plaintiffs, so it says negligently, if the plaintiffs are private figures, which they are, or with actual malice, if plaintiffs are public figures, which they're not. The statements have caused, both by the original publication and the republication around the world, great harm to plaintiffs, and such damages are presumed, and in any event exceed $1 million. In considering whether the 75,000 jurisdictional amount has been reached, the court can take notice that many recent awards, and he names the statements or settlements. Oh, he has let's see. He has Freeman and Moss versus Giuliani, because that was that case that Giuliani had to pay because he defamed like those poll workers, if I'm not mistaken. Or settlements. Dominion Fox, Fox had to pay Dominion this money, and then Trump ABC had to pay Trump this money, far exceed that amount. Although Lively is a public figure, Wallace and Street are not. Thus, plaintiffs need prove only negligence to establish liability. However, plaintiffs also seek punitive damages in the amount of not less than $6 million. And to satisfy the evidentiary burden in establishing the right to such damages, they must demonstrate actual malice. That is that Lively either knew the allegations were false at the time she made them, or she acted in reckless disregard of the truth, that she had a high degree of awareness of falsity in fact entertained serious doubt about their truth. She acted with malice because she was the one claiming to have been harassed and retaliated against. She was the only one who claimed she had contract with plaintiffs, and yet there was no such contract, and plaintiffs were nowhere near where the alleged harassment retaliation took place. Lively knew this, and it is not the case that she was harassed by some masked stranger who turned out to be plaintiff. She knew and knows that they were not the harasser, retaliators, but made these allegations anyway, leaked them to the press, hoping that they would be widely republished, which they were, but then excluded plaintiff from the former lawsuit, knowing that they had nothing to do with the event depicted herein. Plaintiffs under federal rule of civil procedure demand a jury trial. His prayer, number 5, plaintiffs therefore respectfully requested this court to enter a final declaration judgment under 28 U.S.C. 2201 as requested, supra, and award damages for plaintiffs' loss of reputation and for further relief at law or in equity as to which plaintiffs may be entitled. And so this was respectively submitted on February 4th, 2025, which was 2 days ago. And this is a wonderful thing that something is just as short and sweet as this. I actually love it here when it's like that. What are y'all thinking? Give me one moment. We have, let me open this folder real quick. So let's see what we have here. So we have the CRD complaint he put in his lawsuit. We're just going to review it. Complaint of the employment discrimination before the state of California Civil Rights Department. And it's in the a matter of Blake Lively versus. And as we scroll down, we see right here, Jed Wallace, Street Relations. We see his name right here. And so these are all the people that were named in the CRD complaint. Wayfarer Studios, Justin Baldoni, Jamie Heath, Steve Sarowitz, Melissa Nathan, the agency group PR LLC, Jennifer Abel, WRA Communications LLC, Jed Wallace, Street Relations Inc. And they named all of these people as co-respondents. Wayfarer Studio as a respondent and everybody else being the co-respondent. They allege that on or about December 20th, 2024, respondent took the following adverse actions. Complainant was harassed because of complainant's her sex, gender, or harassment, hostile environment. She experienced retaliation because the complainant reported or resisted any form of discrimination or harassment as a result of other adverse action. Additional complaint details. She alleged that the respondent, Wayfarer, Justin, all of these people, let's see, conduct includes harassment, retaliation, failure to investigate, prevent, and or remedy harassment, and aiding and abetting harassment. Please see attached complaint. And they verify this. So this is the cover sheet that I believe that she had to show. Here is the precursor. So here's what was filed. And we do see here, because I'm not going to read any of this. I'm just wanting to show you this is what he was talking about, that his name was mentioned in this complaint. And this is after that, the California Civil Rights Department issued a right to sue letter to, and then that is when Blake Lively sued Baldoni. So here it is, the letter that the CRD gave Blake Lively that a notice to file a discrimination lawsuit. All right, people. What are y'all thinking? How do you think this affects the lawsuit in New York? Because clearly, this man is saying that he didn't do any of these things. He had no contract with her, so he could not have harassed her, is what he's saying. What do you all think about that? Like I said, I just wanted to come on here because we did hear about it the day before. I got a copy of this, and so I wanted to go over it to see, like I do. I read them and we go over it. And we also understand that Blake Lively's team went down to Texas. And then we also find that has been, whatever she filed in Texas, she dismissed it. So this is a lot. There's a lot of stuff going on. So there's lawsuits abound. We just wanted to go over this because we knew that she had gone down to Texas. Now we understand who is in Texas and what happened. I don't have a copy of her. Hold on. Okay, that's the Elle magazine article. Hold on real quick, because there's other documents in here. Okay. There's a civil cover sheet, I guess he had to fill out. And then there's exhibit 4, the Elle magazine. I'm sorry, I'm not even sharing this with y'all. And then he shared the Elle magazine article that was printed on January 3rd, and I think he said that there was a hyperlink. There was a link to his stuff. So here are the links that are in this article. And there he is. He's mentioned right here. Here's the link per the legal complaint. The wildest claim from Blake Lively's legal complaint, the 81-page filing. So here's all the information. There's this, he has that listed in there as well. So listen, I just like for us to stay abreast of what's going on and all the little legal filings that have been, most of them. I'm not going over all of them, but anytime there's a complaint or anytime there's a letter that has great significance, we will definitely go over it and try to figure it out. Because right now it is, I really don't know if there's anything else that needs to come out. I do see that this the information that continues to come out, people, it's great content for content creators. I will tell you that. I do not see, unless something happens again and the judge says that he's going to move this case up, I don't see anything further happening, because again, I think all the information as we know it is out there, unless she has some stuff that she's keeping close to the vest, which is her right to do. But pretty much all the information is out there. Pretty much the complaints, the people who are being sued, people who are filing lawsuits have filed lawsuits. Lawsuits have been consolidated. So it's just a matter of the court case coming. Now, a lot of people do not believe that this will go to trial. They're saying that all of the plaintiffs will get together and come up with some settlement agreement. Don't know what that settlement agreement is or how that looks. I would love to see that, there'll be apologies in the public, because it's played out in the public. Let there be apologies in the public. But I will say that all parties involved, their reputation has been tainted. Regardless if you're, your team Lively, if you're team Baldoni, their reputations have been tainted. And if you watched my last video, you saw that there was some indication that Ryan Reynolds' star power, or people not wanting to be involved in all of this or have their name attached with it in any way, that he went from having 20 projects in the work to now having about 9 projects in the work. And I'm wondering if those 9 projects are projects that he is getting ready, everything has been put forth and now they're getting ready to do those projects. And that's fine, because I don't believe in people losing work. I just personally don't. I think you can do all of these things and people still can work, because people still have bills to pay and things to do and all of those different things. So, but he's got the Blake and Ryan, their reputation in Hollywood is starting to wane. And what I mean by that is that, people are starting to, again, people don't want to be caught up in no mess, lawsuits and all this other stuff. You think about the PR crisis team on both sides. Once they're caught up and they've been sued, no one wants to get caught up in that. No one wants to deal with them in the middle of a lawsuit. So we will see, y'all. Like I said, this wasn't going to be long, simply because it was only simply because the lawsuit itself, complaint, was only 10 pages. Let me put this overlay up here real quick so that YouTube knows that it's copyright for educational purposes. But yes, y'all, we'll continue to follow this. Before you leave, make sure you hit that like button. And if you would subscribe. It's free. And we'll do more things like this. Again, if you are a member to my channel, I just wanted to remind you that on Saturday at 4:00, we're having a members only live stream, and we'll be going over a lot of different things, having some fun over there. So I look forward to seeing you all come through. All right, people, we do this every week. Please like, comment, and subscribe. Please share this video if you care. Y'all, please tell a friend, tell a kin, tell a coworker, tell that heifer that you can't stand that I'm over here making these videos. And you all have a wonderful, wonderful rest of your day. And as always, people, bye-bye. And my ASAP Rocky recap, I will recap day 6 and day 7. And day 8. I will recap them tomorrow together. All right. So I'm no longer watching them through the thing because that's like 3 or 4. It's like 4 or 5 hours. It's easier for me to watch it and then to do the recap later because I can do other things while I'm doing that instead of being on live stream. So I'm going to recap them tomorrow. All right, people. Bye-bye.